Okay, in the last video we talked about Planned Parenthood versus Casey coming out of Pennsylvania, and we talked about 3 provisions of the Pennsylvania law that were upheld, those being informed consent requirement, a 24-hour wait, and routine record-keeping provisions of the law. Now we get to 2 parts of the law that require a little bit more extensive discussion. The first is parental notice, and you can see the tension here between, it's interesting, as an academic matter and as a constitutional matter, the tension between 2 different rights. On the one hand, you have the right of a woman, a female, to terminate a pregnancy, pre-viability. On the other hand, if that female happens to be a minor, that's why I use the word female instead of woman, because we're talking about a minor. If the female happens to be a minor, you also have courts having recognized the fundamental right of a competent parent to direct the care, custody, and control of his or her children. So, any parents out there, you know, before a school gives your kid an aspirin, before somebody touches your kid in a medical way, they're going to try to get your consent because you are directing the care and control of your child because you're the one in custody. So, what do we do with this? In more cases than one, so Pennsylvania is not the only state that has this, right? There have been other cases that went up to the Supreme Court involving parental notice like this. What the Supreme Court has said is this: when it comes to a minor deciding to terminate a pregnancy, if the state requires that the minor inform parents and or get the consent of a parent or parents, the state must provide what is called a judicial bypass in the law. Judicial bypass, once again, you got to stop and say, what is that? Not enough to memorize those words with having no idea what that looks like. Judicial bypass is not heart surgery on a judge, despite what it might sound like. Judicial bypass, in this context, means that there has to be an opportunity for the minor to go to a judge. The way these bypass provisions work in most states is that if a minor is pregnant and wants to have an abortion and is afraid to tell her parents or parents, oftentimes she'll go to somebody like a guidance counselor. She may go to somebody else. Obviously, usually a minor in this position is going to seek some kind of adult guidance. And when I worked for the firm that worked for school districts, there were cases that came in involving minors who had gone to a guidance counselor or a school official of some kind seeking guidance. What will happen then if the minor says, I can't tell my parents, and unfortunately there are often good reasons why a minor wouldn't want to tell the parents. For one thing, I'm sorry, but this is law school and we have to deal with this unpleasantness. I say that 1,000 times in common law. Unfortunately, sometimes the reason a minor is pregnant has something to do with the father. Sometimes one or both parents has a substance abuse problem, has a personality disorder that's acute, is abusive. There's something going on that renders the parent incompetent, frankly, to be involved in a decision like this, and possibly dangerous. So, if a minor alleges essentially that that's the case, the minor, usually under the guidance of some adult somewhere, can get a hold of a family court judge. These hearings are typically expedited for the reason I mentioned earlier. It's hard to get an expedited hearing in an American court in our judicial process. Usually it takes 18 months to go through one stage of litigation. But obviously, again, here we're talking about a gestational period where if you delay, a fetus can move from pre-viable to viable. So typically this would involve expedited hearings. Typically the hearings are in camera, which means in a judge's chambers, obviously outside the view of the public because of the privacy concerns involved. And there's an in-camera hearing. And the judge will attempt to determine whether the minor has valid reasons for not notifying a parent, and if the judge finds the burden of proof, the standard of proof can vary from state to state, but if the judge finds by preponderance of the evidence or clear convincing evidence, whatever the case may be, that a parent would be incompetent, negligent, neglectful, abusive, then a judge can issue an order, give it to the minor obviously, that the minor could present at an abortion clinic, would require the abortion clinic to go ahead and perform the abortion without notifying the parents. So judicial meaning court, bypass meaning go around. And so the court has said, as long as you have that provision in the law where there's a judicial bypass available to the minor, then it is not an undue burden to require parental notice. So that's a bright line rule. I've talked about the abortion cases. You've got your Hellerstedt balancing, right? But you've also got a lot of bright line rules, and that's one of them. It fits into the undue burden framework, but it's a bright line rule that if you're going to have parental notice, you have to have judicial bypass built into it. That is built into the Pennsylvania law, and therefore the Supreme Court says the Pennsylvania law is good to go, does not impose an undue burden on a minor's right to terminate a pregnancy. Then we get to the one part of the Pennsylvania law. This is the fifth component of the Pennsylvania law, and the one part that is actually struck down. And that is the part that requires spousal notice. Now, if a woman wants to have an abortion and doesn't want to tell her husband, because at the time of Casey there was no same-sex marriage, usually there's some reason why the woman would not want to tell the husband. The most obvious is that it would not, that biologically, the child would not be his. But there would be other reasons as well. Even if the child is his biologically, that might cause even more angst, more stress, more anxiety, more tension in the marriage than if it was not. Because if the woman wants to terminate the pregnancy and the husband doesn't, well, we've got ourselves quite an issue here. Students often ask, what is the role of the biological father in these abortion cases? And sometimes students get mad at me when I tell them the answer. But the answer is this: when courts look at the abortion cases, they say we've already got too many interests in play here. We've got the woman, we've got the unborn, we've got the state, we've got all this going on. No way are we throwing in a fourth. So the answer is that in these abortion cases, the issue is the right of the woman. The courts do not treat the biological father as having a cognizable interest in these cases. So it does not consider that. Now, what the court says here, it's interesting. Number one, you have to apply the undue burden standard, and the undue burden standard is a substantial obstacle. So first of all, you'd look at it and say that would be a substantial obstacle. For the state to be telling a woman, you have to tell your husband if you want to have an abortion, there could be cases where that would be outcome determinative, where it would just really be a burden in many ways, psychological, emotional burden, a burden on the relationship, very concrete ways. So there's that. Now in Casey, the court hasn't gotten to Hellerstedt yet, where it starts to do a balancing test, right? Casey, they're just saying, is it a substantial obstacle? Is it too big? They say, yeah, it's a big obstacle. But what they really hang their hats on, and I hope you caught this, is this notion that if what I'm speaking, channeling the court here, the court's saying, we've already decided in multiple cases about the state's role in somebody's marriage. And the state's role in somebody's marriage, remember this stuff, Griswold, marriage, marital privacy, whose business is your marriage? It's yours, it's not the state's. The court is actually offended that the state has in any way tried to inject itself into the marital relationship, requiring communication where one of the spouses doesn't want to communicate with the other. So the court says, even despite the fact that there's a provision here that would allow a woman to kind of certify that she cannot tell her husband, the court says, you know what, even if you tailor this thing to provide an escape valve for the woman, The point is, the state shouldn't be dabbling in this area at all. A marital relationship is between the two spouses. There is no role for the state in that relationship. So the court says, again, not just based on the undue burden standard, but seemingly also based on the fundamental liberty interest of marital privacy, that the state may not require spousal notice. So that is the one part of the law that is struck down in Casey. So to review briefly, you have examples in Casey of laws that were upheld, 4 of them, and a law that was struck down, 1 of them, upheld. Informed consent, 24-hour waiting period, routine record keeping, and parental notice as long as there's a judicial bypass. Struck down, spousal notice, that is not permitted. States cannot pass laws requiring spousal notice in abortion cases. So, hope that's a helpful review of or discussion of Casey, and we will move on to Hellerstedt in the next video.